Hi, today I'm going to talk to you and read to you from some selections of Pierre-Joseph Proudhon. Proudhon's a Frenchman. He's a member of the French legislature in the 1800s. He's a philosopher, a brilliant man, and as far as I can tell, he writes the first, most explicit and comprehensive treatise against private property. Proudhon is the first individual to call himself an anarchist, and so he, for many people, is considered the birth of the anarchist movement, the person who gives birth to the anarchist movement. And remember, in the 1800s, you have a great amount of revolutions happening throughout Europe. In the youth, in the workers, in an almost unprecedented way, are all thinking about the best way to organize governments and economies to benefit the most amount of people. And so these ideas, socialism, liberalism, and now anarchy, are swimming around the minds of the populations of Europe and blowing up into revolutions. In 1848, you have revolutions in almost every country in Europe. They're not successful for the most part, but nonetheless, you have this revolutionary fervor and ideological battle and this real thirst for information about the best way to form governments and economies. This particular document is called What is Property? And this is the treatise I was talking about, and Proudhon writes this in 1840. And so I'm going to read to you selections from this. It's a 130 or 150 page document, and I'm going to read you about 6 pages of it to try to summarize what I find are the most important points from an anarchist perspective or a socialist perspective. So we begin. The Roman law defined property as the right to use and abuse one's own within the limits of the law. Jus intendi et abetendi rusua gratuens juris ratio patitur, Latin. And I'm probably going to skip the Latin part from here on out because I'm just going to butcher it in my pronunciation. It means, and that's the definition of the right to use and abuse one's own within the limits of the law. The justification of the word abuse has been attempted on the ground that it signifies not senseless and immoral abuse, but only absolute domain. Vain distinction, invented as an excuse for property and powerless against a frenzy of possession, which it neither prevents nor represses. The proprietor may, if he chooses, allow his crops to rot underfoot, sow his field with salt, milk his cows on the sand, change his vineyard into a desert, and use his vegetable garden as a park. Do these things constitute abuse or not? In the matter of property, use and abuse are necessarily indistinguishable. So here Proudhon is saying that if you go back to the original Roman law about property, and the Napoleonic Code is going to be based on the Code of Justinian, which is the greatest compilation of Roman law. So this is why he goes back to the Romans when he's talking about property. So he says that the Romans say property means you can use and abuse whatever you own as much as you like. Do whatever you want with it. And obviously this idea of abuse with property is problematic to your average person. You shouldn't be able necessarily to abuse things just because you own them. And particularly if you're talking about the Romans, they're able to abuse and kill their slaves. And so another Frenchman defending the rights of property at Proudhon's time says that when they said abuse, they didn't mean immoral abuse. They just meant that you could do whatever you wanted. And Proudhon says it doesn't matter because if you have the right to do whatever you want with your property, then property is going to be abused and nobody can do anything about it. So that's why he says it's a vain distinction. That to say that it's not for immoral abuse is pointless because, of course, if people can do whatever they want with their property, they're going to abuse it. He goes on. According to the Declaration of Rights, published as a preface to the Constitution of '93, property is the right to enjoy and dispose at will of one's goods, one's income, and the fruits of one's labor and industry. In the Declaration of Rights, this is the Declaration of the Rights of Man and the Citizen, which is one of the first major documents created out of the French Revolution, which hopefully at this point you know about. He goes on. Code Napoleon, Article 544, says property is the right to enjoy and dispose of things in the most absolute manner, provided we do not overstep the limits prescribed by laws and regulations. And that's the Napoleonic Code, created by Napoleon, as I said, based on the Code of Justinian. The most definitive and comprehensive code of laws, arguably in history, certainly in modern history, and still remains the basis for many of the law codes in Europe. These two definitions do not differ, Proudhon goes on, from that of the Roman law. All give the proprietor an absolute right over a thing. And as for the restriction imposed by the code, provided we do not overstep the limits prescribed by the laws and regulations, its object is not to limit property, but to prevent the domain of one proprietor from interfering with that of another. That is a confirmation of the principle, not a limitation of it. And so he's saying that to tell people they can do whatever they want with their property as long as it doesn't interfere with the rights of another, it simply means that you can't use your property to go against somebody else's property. And so that's not really a limit on property rights. It's actually an affirmation of property rights. Like, nobody can mess with your property. He goes on. There are different kinds of property. One, property pure and simple, the dominant and seignorial power over a thing, or as they term it, naked property. And I'm assuming he's talking about the Napoleonic Code here. Two, possession. Possession, says Duranton, and he's another French philosopher talking about property, or French lawyer talking about property, is a matter of fact, not of right. Toullier, a French professor, property is a right, a legal power. Possession is a fact. The tenant, the farmer, the commandite, the usufructuary are possessors. The owner who lets and lends for use, the heir who has come into possession on the death of a usufructuary, are proprietors. If I may venture the comparison, a lover is a possessor, a husband is a proprietor. And so he says, and this is French law, distinguishes between the owner of property, and they have the right to use and abuse it however they like within the limits of the law, and then the possessor. And the possessor is the person who's actually holding on to the object. I'm holding this coffee cup, it makes me a possessor. It doesn't mean that I own the coffee cup. If somebody loaned it to me, then they are the proprietor of the coffee cup, and they can come and take it from me anytime they want. And then they can smash it up into nothing if they want, because they own it. This double definition of property, Proudhon goes on, domain and possession, is of the highest importance, and it must be clearly understood in order to comprehend what is to follow. From the distinction between possession and property arise two sorts of rights: the jus in re, the right in a thing, the right by which I may reclaim the property which I have acquired in whatever hands I find it. And so this is the right of ownership over a thing. This is the guy who owns my coffee cup can take it back no matter who has it, because he has this right, the jus in re. He owns it, he can take it at any time from anywhere. And the jus ad rem, the right to a thing, which gives me a claim to become a proprietor. And so the jus ad rem is everybody in a community based on private property's right to, at some point in the future, acquire some property. Okay? So it's the right to become, at some point, a proprietor, a owner of property. Thus, the right of partners in a marriage over each other's person is jus in re, and that of two who are betrothed, only the jus ad rem. In the first, possession and property are united. The second includes only naked property. And he's saying, so if you're married, then you each have the right of property over each other, and you possess each other. Like, you're in physical contact, you own each other, you live together, you can touch each other, right? Whereas a couple who is betrothed, right, that's a promise to become property in the future. So you have that naked property in the marriage contract for the future, the betrothal, but they're not yet married, living together, possessors of each other. With me, who, as a laborer, have a right to the possession of products of nature and in my own industry, and who, as a proletaire, enjoy none of them. It is by virtue of jus ad rem that I demand admittance to jus in re. And so what he's saying is, for the laborer who owns nothing, It's the idea of just ad rem that gives him the hope or the right to, in the future, become a proprietor. Proudhon goes on. Property as a natural right. The Declaration of Rights has placed property in its list of the natural and inalienable rights of man, for and all. So this is back to the Declaration of Rights of Man and Citizen. Liberty, equality, property, security. What rule did the legislators of '93 follow in compiling this list? None. They laid down principles just as they discussed sovereignty and the laws from a general point of view, according to their own opinion. They did everything in their own blind way. So they're saying, yes, when they made this Declaration of the Rights of Man and Citizen, this very important document that is the groundwork for the French Revolution, or the thoughts behind the French Revolution, the first big document they make, is made simply on the whims of the people who wrote it. What was their justification? They justified it on Rousseau and on Locke and Montesquieu and Beccaria. But nonetheless, they put those in there because they wanted to put them in there. He goes on, if we can believe Toullier, and this is another French professor, the absolute rights can be reduced to three, he says: security, liberty, and property. Equality is eliminated by the Reims professor. Why? Is it because liberty implies it, or because property prohibits it? On this point, the author of Droit Civil Expliqué is silent. It has not even occurred to him that the matter is under discussion. So this, we assume, very important French professor of law has said, well, the Declaration of Rights of Man has equality within those four rights, but we can actually boil it down to three and leave out equality. And while he makes this statement, he doesn't really justify it in any way and leaves it up to the reader to either assume that he's right and that equality need not be within those four rights, or like Proudhon does, to try to examine it further and see what's now happened to equality, which would seem to be one of the major underpinnings of modern society, of the social contract, the reason that we've become civilizations instead of independent hunters and gatherers or farmers fending for ourselves. Nevertheless, if we compare these three or four rights with each other, we find that property bears no resemblance whatever to the others. That for the majority of citizens, it exists only potentially, and as a dormant faculty without exercise. So he's saying there that with property rights, most people don't have any property, so they don't have any property rights. That for others who do enjoy it, it is susceptible of certain transactions and modifications which do not harmonize with the idea of a natural right. So he's saying even if you are a property owner, governments are going to have the right to take your property when they want, without much justification. And so it's not really a natural right if people can just come and take it from you. That in practice, governments, tribunals, and laws do not respect it. As I said, government feels the right to take your property whenever they feel the need. And finally, that everybody spontaneously and with one voice regards it as chimerical. And a chimera is like a mythical beast with several different animals put together as one, and it's vague, it's undefined. Nobody exactly knows what it means. It's mysterious, and perhaps even frightening. So property, most people don't have it, unlike liberty and security in the social contract. Governments in particular, can take it away whenever they want without real good reason, unlike liberty and security. And nobody really understands exactly what the basis of it is. And that's what makes property different from these other ideas, these other natural rights. Liberty is inviolable. I can neither sell nor alienate my liberty. Every contract, every condition of a contract, which has in view the alienation or suspension of liberty is null. The slave, when he plants his foot on the soil of liberty, at that moment becomes a free man. So he's saying liberty is a natural right, and in a society based on liberty, as many of these European societies are at his point, as America is at this point, you can't sign your liberty away. You can't become a slave of anybody else. Of course, we leave with the major distinction of the American South, whereas if you're black, you're automatically a slave. So he's not talking about that. But essentially, he's saying that in countries that believe liberty is a natural right, something we're born with, like as Candide says, I have the right to point my feet and walk wherever I want to walk, therefore I thought I could walk wherever I want to walk. It comes naturally. In these societies, they can't take your liberty away, right? When a society sees a malefactor, a bad guy, and deprives him of his liberty, it is a case of legitimate defense. Whoever violates the social compact by the commission of a crime declares himself a public enemy. In attacking the liberty of others, he compels them to take away its own. So he's saying, in modern societies based on natural rights, the only way they can take away your liberty is if you've attacked the liberty of others. By attacking another's liberty, you lose your own right to liberty. Liberty is the original condition of man. To renounce liberty is to renounce the nature of man. After that, how could we perform the acts of man? In other words, we're born free. We have the innate ability to do whatever we want. So if people take it away, how can we still be human, right? And that's why liberty is a natural right, and that's why states can't take it away. Likewise, equality before the law suffers neither restriction nor exception. All Frenchmen are equally eligible to office. Consequently, in the presence of this equality, condition and family have, in many cases, no influence upon choice. The poorest citizen can obtain judgment in the courts against the one occupying the most exalted station. So he says there that equality, like liberty, is a natural right equal to all. And in France at this time, it didn't matter whether you were rich, whether you were poor, who your parents were, you still had the same rights to hold government offices as anybody else. And in a court of law, your background or other factors are not supposed to influence the decision, regardless of whether you're poor and the plaintiff is rich in the crime. You're considered equal before the law. This is in the Napoleonic Code, everybody's equal before the law. It is the same with the right of security. Society promises its members no halfway protection, no sham defense. It binds itself to them as they bind themselves to it. It does not say to them, I will shield you, provided it costs me nothing. I will protect you if I run no risks thereby. It says, I will defend you against everybody. I will save and avenge you or perish myself. The whole strength of the state is at the service of each citizen. The obligation which binds them together is absolute. So it's saying, in the social contract, in societies based on that, like France, the society promises to defend your rights no matter what, right? And when you think about this, in our modern society, think about no matter how poor you are, if somebody is robbing your home and you call the police, the idea is that they come and help you no matter who you are. They're willing to risk their lives for you because you are a member of that society, right? So it's a natural right or a natural right based on the social contract. As a member of society, you are promised security from that society. He goes on. How different with property. Worshipped by all, it is acknowledged by none. Laws, morals, customs, public and private conscience all plot its death and ruin. So he's saying property isn't like any of these other rights. It's not like liberty. It's not like security. It's not like equality. To meet the expenses of the government, which has armies to support, tasks to perform, and officers to pay, taxes are needed. Let all contribute to these expenses. Nothing more is just. But why should the rich pay more than the poor? That is just, they say, because they possess more. I confess that such justice is beyond my comprehension. Why are taxes paid? To protect all in the exercise of their natural rights, liberties, equality, security, and property. To maintain order in the state, to furnish the public with useful and pleasant conveniences. So he's saying taxes in and of themselves make sense, right? Because if you agree to this social contract, that you give up a little bit of your freedom to have your freedom protected by others, and if you give up the liberty that you might have had as a hunter-gatherer, running around in the woods, doing whatever you want. You agree not to take away liberty or life from other people, and this is promised back to you by the society. To promise these things back, to provide things like police forces and armies to defend you from other countries, or roads, or, in modern times, indoor plumbing, and garbage, taking your garbage away and putting it in a landfill. These things cost money. So people should pay taxes. But what he's going to argue is, if property is truly a natural right, then the rich shouldn't be required to pay more than the poor for the same security and freedom. Okay, he goes on. Now, does it cost more to defend the rich man's life and liberty than the poor man's? Who, in the time of invasion, famine, or plague, causes more trouble? The large proprietor who escapes evil without the assistance of the state, or the laborer who sits in his cottage unprotected from danger? So he says, first of all, generally speaking, the rich can take care of themselves. It's not like the state has to protect them, right? Oftentimes they have their own private bodyguards or security forces. So to say that they need to pay more money because they cost more money is silly, because they don't. Is the public order endangered more by the worthy citizen or by the artisan and journeyman? Why, the police have more to fear from a few hundred laborers out of work than from 200,000 electors. So he says, look, on top of that, the poor people are more likely to cause danger to the state, so they should be taxed more, right? But no, the rich people are taxed more, even though they really don't pose any threat to the state. They already have everything they want. They're not necessarily going to go around and revolt and steal, etc., etc. Does the man of large income appreciate more keenly than the poor man national festivities, clean streets, and beautiful monuments? Why, he prefers his country seat to all the popular pleasures, and when he wants to enjoy himself, he does not wait for the greased pole. The greased pole, by the way, it was like a carnival game, a festival, and they'd take a pole and plant it in the ground, and they'd grease it up, right? And then they'd have people try to climb to the top of it, right? And everybody would point and laugh and cheer, etc., etc. So what he's saying is, okay, so we provide all these services as a state, clean streets and festivals, etc., and who's going to enjoy them more? The rich? No, they'd rather hang out in their estate. They probably own their own grease pole, right? Or a whole bunch of other more expensive types of entertainment. So on that same note, it's the poor who appreciate these festivities more. So why then should the rich pay more? If property is a natural, inalienable right, how can we justify taking more from one person than from another? One of two things is true. Either the proportional tax affords greater security to the larger taxpayers, or else it is wrong. Because if property is a natural right, as the Declaration of 93 declares, all that belongs to me by virtue of this right is as sacred as my person. It is my blood, my life, myself. Whoever touches it offends the apple of my eye. My income of 100,000 francs is as inviolable as the grisette's daily wage of 75 centimes, or centimes. Her attic is no more sacred than my suite of apartments. The tax is not levied in proportion to strength, size, or skill. No more should it be levied in proportion to property, right? So we don't take more freedom away from people because they're incapable of practicing freedom, because it's a natural right. It's considered part of their inner being. We don't provide less security for people because they're stronger, right, and can secure themselves. No. So why should we provide less property rights to the rich because they're rich? If property is a natural right that comes to us by birth, then it must be treated the same for everyone. And it's not. If then the state takes more from me, let it give me more in return, or cease to talk about equality of rights. For otherwise, society is established not to defend property, but to destroy it. The state, through the proportional tax, becomes the chief of robbers. The state sets the example of systematic pillage. The state should be brought to the bar of justice at the head of those hideous brigands, that execrable mob which it now kills from motives of professional jealousy. right? So, like the state is going to crush a mob of people trying to overthrow the state and take their power, right? The state should be crushed, in this case, by the rich, because the state is robbing the rich of their natural right to property, right? Just because they have more. But they say, and this is Proudhon offering the counter argument to his argument, but they say the courts and the police force are established to restrain this mob. Government is a company not exactly for insurance, for it does not insure, but for vengeance and repression. So what he's saying is the government doesn't ensure that bad things won't happen. It just will get revenge for you in case bad things do happen. The premium which this company enacts, the tax, is divided in proportion to property. That is, in proportion to the trouble which each piece of property occasions the avengers and repressors paid by the government. So he's saying the alternate argument is it costs more to protect more property, therefore we should take more money from you, right? But as Proudhon has argued previously, generally speaking, the property of the rich is already protected and it doesn't need any more protection, right? So why do they take more money from them? One possible answer is because the rich, to secure their property rights from all the people who are poor, powerless, and propertyless, are willing to pay more to keep those angry mobs from taking their property. This is anything but the absolute, Proudhon goes on, an inalienable right of property. Under this system, the poor and the rich distrust and make war upon each other. But what is the object of war? Property. So that property is necessarily accompanied by war upon property. The liberty and security of the rich do not suffer from the liberty and security of the poor. Far from that, they mutually strengthen each other. The rich man's right of property, on the contrary, has to be continually defended against the poor man's desire for property. What a contradiction. So he's saying, look, the liberty of the poor person does not hurt the liberty of the rich person. In fact, it strengthens the liberty of the rich person because they're mutually dependent on respecting each other's freedom. And the security of the rich person doesn't take away the security of the poor person because they're both obligated to support the same armies. They're both obligated to protect the citizens of the country, right? Like strength in numbers, okay? The more people looking for security from each other, the more secure they're going to be. And he says, but property isn't like that at all. When you give people the rights to own property, the people who have the more property are immediately on the defensive from everybody else who has no property and wants it to live, right? So he says the right to private property immediately causes warfare. Because what are wars fought over? Property. Okay, he goes on. In England, they have a poor rate that they wish me to pay this tax. And this is essentially, in England, they have a tax to help out poor people. But what relation exists between my natural and inalienable right to property and the hunger from which 10 million wretched people are suffering? He's saying, okay, great, right? So they're suffering, maybe somebody should feed them. But if I have a natural, inalienable right to property, which all these documents suggest that I do, starting with the ones in the French Revolution, then how can you just come and take my property to feed people? It's my natural right. You don't take my liberty to feed people. You don't take my security to feed people, right? But you can suddenly take my property, which you promised me before was a natural right. He goes on. When religion commands us to assist our fellows, it speaks in the name of charity, not in the name of law. The obligation of benevolence imposed upon me by Christian morality cannot be imposed upon me as a political tax for the benefit of any person or poorhouse. I will give alms when I see fit to do so. I'll give charity and money. When the sufferings of others excite in me the sympathy of which philosophers talk, and in which I do not believe. So he's saying, look, when the church asks you to give money to the poor, they ask you to do it out of charity, out of free will, because you want to help these people out. They don't say you must give. That's his argument. It's not a law. It's an appeal to your conscience. Two different things, right? An appeal to your conscience allows for freedom, and it respects your rights to property. A law taking money away from you to give out to the poor does not respect your rights of property or your freedom. No one is obliged to do more than comply with this injunction, he goes on. In the exercise of your own rights, do not encroach upon the rights of another. An injunction which is the exact definition of liberty. My right to swing my fist ends at your nose, right? Now my possessions are my own. No one has claim upon them. I object to the placing of the third theological virtue in the order of the day. And so he's saying, look, just like my right to move and exercise my free will is only impeded when it hurts somebody else, my right to property should not be impeded unless it hurts to somebody else. So don't take my property based on some theological, which just means religious, virtue, right? When you say it's my natural right to own it. If it's my natural right to own it, I should be able to own it. You can't take it. At least you can't take it in an unequal way compared to everybody else in society. To sum up, liberty is an absolute right because it is to man what impenetrability is to matter, a sine qua non, a must-have, a condition of existence. Equality is an absolute right because without equality, there's no society. Security is an absolute right because in the eyes of every man, his own liberty and life are as precious as another. These three rights are absolute, that is, susceptible of neither increase nor diminution. Because in society, each associate receives as much as he gives. Liberty for liberty, equality for equality, security for security, body for body, soul for soul, in life and death. And so he's saying in the social contract, right, we all come together to protect our own freedom, to protect our own equality, and to protect our own security, or to be secure. Right? That's the idea of the social contract in Rousseau, the idea of the social contract in Locke, right? We agree to work together as equals to protect our freedom and to be secure, right? But property, in its derivative sense and by the definition of law, is a right outside of society. For it is clear that if the wealth of each was social wealth, the conditions would be equal for all. And it would be a contradiction to say property is a man's right to dispose at will of social property. So he's saying, look, if property really were a natural right or a right that comes with the formation of society, then it would naturally be equal because natural rights are equally shared by all humans because they come to us by nature of being human, right? And therefore they're equal. And when we form a society, everybody has an equal amount of freedom, an equal amount of security, but they don't have an equal amount of property. And he says, if property was truly a function of society, then like liberty and security, it would be equal. But it's not, because property rights give individuals the right to dispose of their own property at their will. And if you wrote that law to say they could dispose of the property of society at their will, then it wouldn't be the property of society. It would be the property of individuals. Then, if we are associated for the sake of liberty, equality, and security, we are not associated for the sake of property. So property is not the reason that man comes together, is what he's saying in the original origin of society. Then if property is a natural right, this natural right is not social, but antisocial, right? And what he's saying here is if property is natural, if people are born with the right to own and do whatever they want with everything they can get their hands on, then that actually works against society because it causes society to break apart, to fight against itself, to cause wars. Property and society are utterly irreconcilable institutions. It is impossible to associate two proprietors, as impossible to associate two proprietors as to join two magnets by their opposite poles. Either society must perish or it must destroy property, right? So A society based on equality and freedom and security cannot also be based on property, because private ownership of property, Proudhon is arguing, is going to destroy equality, destroy liberty, and destroy security. If property is a natural, absolute, imprescriptible, and inalienable right, why in all ages has there been so much speculation as to its origin? For this is one of its distinguishing characteristics, the origin of a natural right. Good God, whoever inquired into the origin of the rights of liberty, security, or equality, they exist by the same right that we exist. They are born with us. They live and die with us. With property, it's different indeed. By law, property can exist without a proprietor, like equality without a subject. It exists for the human being who yet is not, and for the octogenarian who is no more. He's like, the ownership of property exists for people before they're born, because they're going to inherit what their parents have. The property, the right of property, exists after people die, because people die and they have wills. The property is still theirs, and then it's given out to who they want it to. No other natural right is like that, right? When you die, your right to security is over. It exists in your person, right? Not outside your body, as property does. When you die, your freedom is over. You're dead. Right? But when you die, your property continues to go on, and it can't be a natural right. It doesn't exist within the person. And yet, in spite of these wonderful prerogatives, which savor of the eternal and the infinite, they have never found the origin of property. The doctors still disagree. On one point only are they in harmony, namely, that the validity of the right of property depends on the authenticity of its origin. But this harmony is their condemnation. Why have they acknowledged the right before settling on the question of its origin? So he says, look, all these philosophers, all these folks, and it's pretty much everybody at the time, who believes that private property is a natural right. They all say it's a natural right because it's always been a natural right. But they don't agree on how it became a natural right? There's disagreement there, and he's going to go into some of this disagreement here. Certain classes, he goes on, do not relish investigation into the pretended titles of property and its fabulous and perhaps scandalous history. They wish to hold to this proposition, that property is a fact. It has always been and always will be. With that proposition, the savant Proudhon commented in his treatise on the right of usufruct, regarding the origin of property as a useless question. Perhaps I would subscribe to this doctrine, believing it inspired by a commendable love of peace, where all my fellow citizens in comfortable circumstances, but no, I will not subscribe to it. So he's quoting himself here, and he says, at one time, he says, it's useless to even look into the origins of property, because that could lead to revolution, not peace, because property has problematic origins, right? But he says he's not comfortable in just giving up on looking at the origins of property just to prevent a revolution, because as he looks around him, so many people are miserable because of property, and so therefore it must be looked into. Section 2, Occupation as the title of property. The titles on which they pretend to base the right of property are two in number, occupation and labor. I shall examine them successively under all their aspects and in detail. And I remind the reader that to whatever authority we appeal, I shall prove beyond a doubt that property, to be just and possible, must necessarily have equality for its condition. So the only way that property makes sense as a natural right is if everybody has equal property. It is remarkable that at those meetings of the State Council at which the Code was discussed, no controversy arose as to the origin and principle of property. And he's talking about the council that created the Napoleonic Code. Napoleon headed this council himself. All the articles of Volume 2, Book 2 concerning property and the right of accession were passed without opposition or amendment. Bonaparte, who on other Sorry, it cut me off to process the film. So he left off with Proudhon's comments on Napoleon. He says, Bonaparte, and sorry if this is a repeat of what just happened, Bonaparte, who on other questions had given his legalists so much trouble, had nothing to say about property. Be not surprised at it. In the eyes of that man, the most selfish and willful person that ever lived, property was the first of rights, just as submission to authority was the most holy of duties. So he's saying, yeah, Napoleon had no problem with property rights, but Napoleon is one of the most selfish people the world has ever seen. So he has no problem with property rights, just like he thinks the most holy duty of any citizen is submission to authority, like submission to Napoleon. The right of occupation, or of the first occupant, is that which results from the actual, physical, real possession of a thing. I occupy a piece of land. The presumption is that I am the proprietor, until the contrary is proved. We know that originally such a right cannot be legitimate unless it is reciprocal. The jurists say as much. And so what he's saying here is one of the bases for property rights was occupation. Like if you were on a piece of land, it was yours, right? And he says that the most important piece of this, or one of the most important pieces, is its opposite. If you are not on a piece of land, it's not yours, right? And he goes on, Cicero compares the earth to a vast theater. And in the reading, it has this long, long quote in Latin, which I'm not going to butcher this time. This passage is all that ancient philosophy has to say about the origin of property. So here he's saying Cicero, the great Roman philosopher, had something to say about property, and which is the only record that he finds in ancient history about the origins of property, in the Western world at any rate. And so here's what Cicero says. Proudhon goes on. In theater, says Cicero, the theater, says Cicero, is common to all. Nevertheless, the place that each one occupies is called his own. That is, it is a place possessed, not a place appropriated. It's a place where you're standing, not a place that you've taken without being there, right? So the theater is common to everyone. Everybody shares it, but when you're standing on the theater, that spot that you're standing on is yours. This comparison annihilates property. Moreover, it implies equality. Can I, in a theater, occupy at the same time one place in the pit, another in the boxes, and a third in the gallery? Not unless I have three bodies, like Geryon, or can exist in different places at the same time, as is related of the magician Apollonius. According to Cicero, no one has the right to more than he needs. Such is the true interpretation of his famous axiom, another quote in Roman here, to each one that which belongs to him. An axiom that has been strangely applied. And so he's saying here that Cicero meant that nobody had a right to more than they needed, more than they were occupying at that time, and more than they needed to give themselves sustenance. And he says, but lawyers and legalists of his time have reinterpreted Cicero's ideas to mean that which belongs to each is not that which each may possess, but that which each has a right to possess. So he says people now say that Cicero actually meant that you needed, or you could own, way more than you needed, that you actually had the right to possess anything, right, as long as you could legally acquire it. Now, Proudhon goes on, what have we the right to possess? That which is required for our labor and consumption. Cicero's comparison of the earth to a theater proves it. According to that, each one may take what place he will and beautify and adorn it if he can. It is allowable, but he must never allow himself to overstep the limit which separates him from another. The doctrine of Cicero leads directly to equality, for occupation being pure toleration, if toleration is mutual, and it cannot be otherwise, the possessions are equal, right? And so Cicero's argument is that we each occupy a place on earth, and we have a right to beautify that place on earth as long as we tolerate everyone else's equal right to possess and occupy their place on earth and to get the things that they need to survive. This means that the property, or infers, directly implies that the amount of property that each has a right to is equal. He goes on, and this is the argument against Cicero's idea. Grotius, and this is another philosopher who's going to support private property, rushes into history. But what kind of reasoning is that which seeks the origin of a right said to be natural elsewhere than in nature? This is the method of the ancients. The fact exists, then it is necessary, then it is just, then its antecedents are also. Nevertheless, let us look into it. And so Grotius, this philosopher who supports private property, is going to look for a right to property somewhere other than the natural state of man, state of nature. And Grotius says, and this is Proudhon quoting Grotius, originally all things were common and undivided. They were the property of all. Let us go no further. Grotius tells us how this original communism came to an end through ambition and cupidity, how the age of gold was followed by the age of iron, etc. So that property rested first on war and conquest, then on treaties and agreements. But either these treaties and agreements distributed wealth equally, as did the original communism, the only method of distribution with which the barbarians were acquainted, and the only form of justice of which they could conceive. And then the question of origin assumes this form. How did equality afterwards disappear? So he says, look, if your argument, and he's talking to Grotius, is that the right to property comes from war and cupidity, right? Then either that creates equality, or it's founded on something that goes against equality and security, the other natural rights of man. And he's also saying that the barbarians that the Romans conquered believed that each had an equal claim to the property that they were standing on or they needed. Or else, Proudhon goes on, these treaties and agreements were forced by the strong upon the weak, and in that case they are null. The tacit consent of posterity does not make them valid, and we live in a permanent condition of inequity and fraud. So he says, if this is the best argument for private property, that it originates by greedy people taking it by force from other people, then that is no argument at all in a society that believes in liberty, security, and equality, right? Property is not a natural right. Property is only a right that was stolen from the many by the few through strength, through lies, through manipulation,